everybody, and thanks for joining us in our Federal Government Contracting Webinar Wednesday series. This is Jennifer Schaus, and we're coming to you live from Washington, D.C. Our webinars are held every Wednesday. They're complimentary and recorded. You can find the recordings usually 24 to 48 hours later on our YouTube channel and on our website. Our YouTube channel now has over 300 complimentary government contracting webinars available for download. In the interest of time, we do not take questions. So if you've got questions for our speaker, Megan Connor, her information will be on the very last slide, and we encourage you to reach out to her directly for any questions that you've got about OTAs today. We also want to thank the National Veterans Small Business Coalition, the NVSBC. They're the largest nonprofit trade association for veterans. Great organization, and encourage you to visit their website, which is listed here on the slide. A little bit about us. We provide professional services for product, service, and software companies across the U.S. and actually across the globe. We work with companies of all shapes and sizes and help them with anything from contract vehicles to proposal writing and compliance. We've got an event coming up on Monday, February 10th. It'll be at the Kennedy Center in Washington, D.C. We've been doing these events at the Kennedy Center for about 15 years. We've got about 150 folks who have registered. The government agencies who will be on site to talk to you include Department of State, HHS, and from DOD, we've got NAVAIR. So you can register for the event on our website. There is a section called Events. Scroll down to February 10th, and the registration link is there. Our newsletter goes out every Monday and reaches almost 17,000 subscribers. That includes both government and government contractors. If you want pricing on that, please send us an email and we will send you the pricing information. Okay, our speaker today is Megan Connor. She's with Flaherty Mazza, a great law firm here in DC, and she's going to be talking about OTAs. So Megan, I'm going to turn the floor over to you and just let me know when you're ready for your next slide.
Sure, let's go ahead and get started. Next slide, please. Perfect. So the OTAs are very popular and have been for the last couple of years, and I know that we're going to touch on the consortia, but I wanted to give a little bit of history on OTAs and how they came to be. They started with NASA back in 1958, and then were rolled out to different agencies, DOD, DOE, HHS, DHS, and DOT over the last several decades. DARPA was initially granted the authority, and then it was expanded to all of DOD in 1991. Next slide, please. This table provides a list of the current agencies with OTA authority. And I use OTAs, that acronym often refers to both other transaction agreements and other transaction authority. So other transaction authority is the statutory authority of an agency to enter an other transaction agreement, both of which are confusingly referred to as OTAs. Some of these do have sunset provisions. So for instance, the DHS authority, it expired at one point at the end of FY17, but then has been renewed. DOD is the most popular and constant. So this webinar focuses on DOD's authority. One Bloomberg report that I recently saw indicated that DOD's OTA spending in fiscal year 2019 exceeded $7 billion. It was at $4 billion for FY18 and roughly half of that for FY17. So it's obviously steadily increasing. Next slide, please. Part of that increase is because the Pentagon is really pushing for the use of the OTAs on R&D projects. The Pentagon issued a digital modernization strategy in July of 2019, urging procurement officials to look to OTAs when they can. The Pentagon sees OTAs as a way of getting R&D projects done quickly, and we'll get to this, but the process can really, these can be awarded in a matter of weeks versus months, like a traditional procurement contract. OTAs are really for R&D, so they're for basic, applied, and advanced research projects and for prototype projects. And the expansion of the definition of prototype projects and the authority was made permanent in the 2016 National Defense Authorization Act, and that's really driven the increase in OTA spending the last couple of years. Prototype projects under OTA are meant to be directly relevant to enhancing the mission and effectiveness of military personnel and the supporting platforms, systems, components, or materials proposed to be acquired or developed by DoD. And they also must be directly relevant to improvements of platform systems, components, or materials in use by the armed forces. You can see the references to supporting platform systems, components, or materials, or the improvement of platform systems, components, or materials. It's very broad. Potentially something like a program, not necessarily something that you hold prototype, but like a pilot program of something could be considered a prototype. Prototype project authority dollar thresholds also were recently doubled in the 2018 NDAA, which again just shows this push to the use of OTAs by DoD. Next slide. So there are 4 conditions, at least one of which must be met in order for DoD to be able to use its OTA authority. So the first condition, in the next couple of slides, we'll touch on each of these. The first condition is that there must be at least one nonprofit research institution or non-traditional defense contractor participating to a significant extent in the prototype project. And I'm going to define significance in a couple of slides. This is really meant to grab commercial companies operating out of Silicon Valley. They want to grab those non-traditional defense contractors who are pushing the boundaries on technology, but maybe are not interested in doing business with the federal government because of all the regulatory requirements that come along with it, like, for instance, the cost accounting standards. So that's why part of this definition of what a non-traditional defense contractor is an entity that is not currently performing and has not, for at least the 1-year period preceding the solicitation for the transaction, performed any contract or subcontract for DoD that is subject to full coverage under cost accounting standards. Next slide. These are the second and third conditions, again, at least one of which must be met. All significant participants in the transaction are small businesses as defined by the Small Business Act or non-traditional defense contractors. At least 1/3 of the total cost of the prototype project is to be paid out of funds provided by sources other than the government, generally privately funded. And I'm going to explain that 1/3 rule shortly. Or next, the senior procurement executive for the agency determines that exceptional circumstances justify the use of the transaction for innovative business arrangements or structures that would not be feasible or appropriate under a contract. So this is obviously a huge catch-all, that notwithstanding that none of the other conditions are met, so we're not dealing with a non-traditional defense contractor, we're not dealing with a group of small businesses, we're not dealing with the prototype project developed at least 1/3 at potentially private expense. This is a catch-all for a senior procurement executive to approve the use of an OTA. And this is meant to capture the large contractors that are already doing business with the federal government. And to illustrate that, Microsoft was actually one of the largest recipients of OTA obligations last year, tied to a virtual reality program that they're rolling out with the Army. So it goes to show you Microsoft is a large federal contractor, and they are also a large recipient of OTA obligations under this 4th condition. Next slide. I mentioned the word significant and significant participation either by small businesses or non-traditional defense contractors. And significant is meant to capture that the entity, non-traditional defense contractor and or small business, is supplying a new key technology or product, is accomplishing a significant amount of the effort, is causing a material reduction in cost or schedule, or causing an increase in performance. And again, they're not numbers tied to this. These are broadly phrased to give DoD some discretion in how they can make these OTAs happen. Next slide. The 1/3 test is that the general rule, the amounts counted for purposes of the funds provided by sources other than the government do not include costs that were incurred before the date on which the OT agreement becomes effective. Next slide. However, costs that were incurred for a prototype project by a party after the beginning of negotiations resulting in an OT agreement with respect to the project before the date on which the transaction becomes effective may be counted. So if you start negotiations with DoD on an OTA, and as part of those negotiations, you start developing the prototype, then if those costs reflect 1/3 of the cost, then those would qualify for the 1/3 test, which again goes to one of the conditions that must be met for a prototype project OTA is at least 1/3 of the total cost of the prototype project is to be paid out by funds other than government sources. So these can be incurred even before entering the OTA agreement if you're in negotiations with DoD. So long as the official responsible for entering the OTA determines in writing that the party incurred the costs in anticipation of entering the OTA, and it was appropriate for the party to incur the costs before the OTA became effective in order to ensure successful implementation of the agreement. Next slide. Cost sharing is discouraged when it's a defense unique item involved. And by cost sharing, the mixture of private and public funds. And the reason is, there are a couple of reasons, one of which is an IP related issue. When the government pays for something, for the development of a prototype in this instance, or a defense unique item, the government's IP rights are the broadest. The more private expense involved, the fewer IP rights the government has. And obviously the sensitive nature of defense unique items is a reason why cost sharing is also discouraged. Next slide. So a OTA for a prototype project may allow for the award of a follow-on production contract or just a follow-on OTA. However, that's only possible if the initial OTA was competed in some way. If the initial OTA for the prototype was not competed in some way, and then the OTA also provides for a follow-on to the awardee, then that is a violation of the OTA authority and is potentially protestable. So if you have a prototype OTA and you also want the follow-on production work for that prototype, then we want to make sure that the OTA for the prototype was competed in the initial step, and that assures that you can receive a directed award for the production OTA afterwards. Next slide. Now that brings up an important distinction between OTAs and traditional contracts. An OTA is technically a contract. It has all the elements of an enforceable contract from a legal perspective, but it is not considered a, quote, procurement contract. So it's not subject to the FAR, it's not subject to DFARS, it's not subject to the Competition and Contracting Act, also known as CICA, but to the maximum extent practicable, competitive procedures shall be used. Notice that mandatory language, shall be used. So the Congress still wants some competition to happen to the extent possible, even though, again, these contracts are not subject to CICA. They're not subject to other procurement statutes like Procurement Integrity Act. It's very common for consortia to pursue and enter OT agreements, and these consortia don't really come into play in the traditional procurement contract. They may be subject to protest, and I just touched on that with regard to the prototype and follow-on, but you would have to show that the agency strayed from the applicable OTA statute. The one protest that I have seen on this involving Oracle and the JEDI Cloud contract dealt with, or excuse me, not JEDI Cloud, it was in the Oracle challenge. And the prototype contract had been awarded without competition. And then the follow-on production contract was also awarded to the same awardee without competition. But again, because there was no competition on the first phase for the prototype OTA, there was a challenge to that as to whether the prototype or the production contract could be awarded. Also on the protest piece, that the Oracle protest was before the Government Accountability Office. The Court of Federal Claims has issued differing decisions on whether the court has jurisdiction over OTAs under the Tucker Act. The Court of Federal Claims procurement jurisdiction is all based on Tucker Act jurisdiction, and there's a question about whether an OTA qualifies as a contract for purposes of the Tucker Act. It's also unclear how disputes under an OTA are to be handled because they are not subject to the Contract Disputes Act. And the Contract Disputes Act dictates for experienced contractors that have had to go through the claim or certified claim process. The Contract Disputes Act is what controls that dictates that the contractor must submit the claim to the contracting officer for a final decision. And once you have that final decision, you have the right to appeal it to a Board of Contract Appeals or to the Court of Federal Claims. None of that applies to an OTA. So if a dispute does arise in a contractor's performance on an OTA, there is an open question as to how that dispute is to be resolved. Now, even though it's not subject to the FAR, it's not subject to procurement statutes, there's a question about how to resolve protests and disputes. It is possible that because this is a negotiated contract between parties, it is possible that the OTA itself may include provisions on, for instance, how disputes are to be resolved. Next slide. OTAs are similar to the traditional procurement contract in that competitive procedures are encouraged. They are in writing. The participant, the awardee, has obligations to the government just like a traditional prime contractor does. And although we're going to touch on the consortia, and the consortia are the most popular way in which OTA obligations are flowed through to the awardees, besides consortia, entities entering OTAs can be a single company, a joint venture, a prime contractor, a partnership. I mean, it can look like a traditional contract as far as the parties. The majority of 2019 fiscal year OTA obligations actually went through consortia, and of that amount, nearly 70% flowed through one nonprofit called Advanced Technology International, which manages contracts for about a dozen consortia. Next slide. For contractors, and truly this slide is really coming from the perspective of traditional contractors, what are some of the benefits of doing an OTA? Is that the standard intellectual property provisions and protections in a traditional contract do not have to be included in an OTA. Now, as I mentioned, because an OTA is a contract that can be negotiated between parties, it is conceivable, and I have seen this, that DoD asserts data rights in an OTA similar to what it would assert in a traditional prime contract, but that's not required. So, that's what the standard IP provisions and protections, those go to the government's data rights and how patents are to be resolved and how copyrights are to be resolved. All of that can be subject to negotiation in the OTA, but it's not mandatory language. Agencies also do not have to require that the entities meet the cost accounting standards or use accounting systems that adhere to these standards. But again, that's something that DoD could put into the agreement. It's just not required. Minimal competition. Competition is encouraged, but it's not mandatory. And there's certainly nothing like, a rule of two, or that you can't do a directed award without determining that there's no other, responsible contractor that can perform. If there's only one responsive entity on an OTA, that's it. I mean, they're going to get the prototype project and very likely the follow-on production contract. There's very low risk of a protest. I mean, protests have happened, but they are very rarely successful because The traditional protest arguments, for instance, an error, an evaluation error, that just, a protester could try to raise it, but it just doesn't come into play when it comes to OTAs. It really boils down to whether the agency, in this case DoD, acted within its statutory authority in making the OTA award. And OTAs also present a faster procurement cycle, mostly because they're not subject to a lot of these Procurement Integrity Act, CICA types of issues. So DoD will issue a request, a call, and the procurement can be done in a matter of weeks. Next slide. So as I mentioned, the vast majority of OTA obligations go through consortia. So what are consortia? Consortia are groups of, contractors, non-traditional contractors, small businesses, research institutions, educational institutions. They form this consortia together. You can submit your membership application online. You sign a membership agreement and pay a fee. And then the managers, there could be one or multiple, issue calls for white papers and proposals. And then the government evaluates the responses and makes an award selection. I think of the consortia a little bit like GSA's role in the Federal Supply Schedule program. That GSA is kind of a gatekeeper on who can get onto the schedule, but then once you're on the schedule, you just go and go through eBuy and find the opportunities and pursue opportunities through the procuring agencies. The consortia do a little bit of that. It's a way of kind of winnowing down the entities that are interested in doing this type of work, and then the opportunities are released to members of the consortia or consortium. Some consortia publish the names of award recipients, but not all do. Next slide. I've provided here a sample list of some consortia, this slide and the next slide. So you can see the C5, which is the Consortium for Command, Control, and Communications in Cyberspace. System of Systems Consortia, SESIC. Consortium for Energy, Environment, and Demilitarization. Defense Mobility Enterprise, National Advanced Mobility Consortium. Next slide. DoD Ordnance Technology Consortium, National Armaments Consortium, Vertical Lift Consortium, National Spectrum Consortium, Medical Technology Enterprise Consortium, Medical CBRN Defense Consortium. So what I recommend is, based on your industry, particularly in the DoD world, if you are already providing products or services to DoD, there very well could be, particularly high-level products, high-level services. There very likely is a consortium that already meets your needs and is doing what the types of services or the types of products that you're providing to DoD. And it's just a matter of getting out there and finding the consortium that kind of fits either where you are now or where you want to go in your business with DoD. Next slide. As I mentioned, the consortium manager would issue a call for proposals. So this is a sample one. C5, which again is the Consortium for Command, Control, and Communications in Cyberspace. C5 released a request for white papers with a 2-week deadline. And the scope was to modernize missile defense communications networks, including the Patriot missile. The ultimate customer was the Army's lower tier project office. The call did say, and this is similar to a traditional procurement contract, that the proposals, the white papers, would be evaluated on a best value basis, and it gave a target range of 45 to 49 million. It stated that a secret clearance was anticipated, but again, it didn't say it was required in order to submit the white paper or in order to receive the OTA. And that the call said it was looking for white papers demonstrating the feasibility, effectiveness, and reliability of the solution, along with how the proposal would address each system element. So it had language that was similar to what you would see in a traditional RFQ or RFP, but with a little more wiggle room, like the clearance requirement and the fact that the dollar value was issued. This one, considering the dollar value, it may have been one of the instances where there was a, potential entity that was previously identified, but it could also just be that they were trying to give respondents a range of where they wanted dollars to go. Next slide, please. I also pulled a sample consortium membership agreement to give you a sense of what you would see in one, and this is with SAWSEC. The annual membership fee is $500. There's a general membership meeting at least once a year. The board of directors governs all business affairs. Data rights would be as defined in the OTA. It addressed export controls, which you would see in a traditional prime contract, flow down to subcontractors as well. It allowed for a voluntary withdrawal of membership with a 14-day advance notice. And the term was 5 years with automatic renewal. Next slide. So those were all of my substantive slides. This is not meant to be legal advice. If you require legal guidance in any specific situation, you're encouraged to engage a qualified lawyer. Next slide. And thank you very much, and please do not hesitate to reach out if you have any questions.
Megan, great presentation, good information on OTAs. Thanks everybody for joining us. And if you do have any questions about OTAs or government contracting in general, and you need legal assistance, please contact Megan Connor. Her email is mconnor@valeriomaza.com, and you can reach her at 202-857-1000. Again, great presentation, and we'll have the recording available hopefully within the next 24 to 48 hours. And we'll post that on YouTube, our website, LinkedIn, and a couple other spots. So thanks again, everybody, and hope to see you next Wednesday for another Webinar Wednesday program. And please join us on Fridays as we cover each part of the FAR. Our Friday webinars are at 12 o'clock, and they're also complimentary. Thanks again, Megan, and thanks again, everybody.